is a judge following the bail statute when, after conducting a bail hearing, the judge orders remand but doesn't say which factors suggest a risk of flight? To find out, you have to read People versus Maginley Liddie, but it's 11 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Maginley Liddie, who's the New York City Department of Corrections Commissioner. The citation for this case is 2025, New York Subopinion 05785. This is a case about a defendant by the name of Guerra. This case was decided on October 21st of 2025. The issue in this case is how specific a judge has to be in terms of describing its analysis, the judge's analysis, in a bail hearing when the judge determines that remand is the securing order the judge will require to ensure that the defendant returns to court. To understand and appreciate the context of this case, the helpful background to know is that over the last 10 years, there's been a lot of changes to the bail system. Before 2019, you could pretty much get bail on almost any crime. And after 2019, the 2019 changes were that essentially there were only certain offenses that were qualifying offenses for which bail or remand could be obtained. And other than that, there was a preference for non-monetary conditions or no bail, no remand. The preference is that people be allowed to fight their cases on the outside, but there are bail qualifying and eligible offenses. But CPL 510.10, which is the bail statute that was modified, says that the court shall make an individualized determination as to whether the defendant poses a risk of flight to avoid prosecution, consider the kind and degree of control or restriction necessary to reasonably assure the defendant's return to court, and select a securing order consistent with its determination. Okay. And then it also lists the variety of factors the court must consider when making that bail determination. The facts in this case are that in August of 2017, defendant Guerra was arrested and charged with multiple counts of promoting and possessing a sexual performance by a child, which is a bail qualifying offense. Supreme Court set bail at $50,000, $75,000 cash. The defendant couldn't make the bail, so he stayed in jail pending the case's outcome, and ultimately the defendant was convicted at trial and sentenced to prison. Then he appealed, and his appeal was the Appellate Division reversed the conviction on certain grounds and ordered a new trial. At that point, his lawyer then approached the court and said, hey, Judge, I would like bail to be reassessed and reduced or withdrawn. The defendant can fight his appeal or fight the new trial on the outside. At that point, the Judge Alois, conducted a bail hearing pursuant to 510.10, and at the end, the judge ruled without elaboration. This is what the judge said. The court has considered all the factors outlined in Section 510.30 of the CPL, and the court finds that the least restrictive means of assuring his return to court is, in fact, continued remand, close quote. The court didn't state that it found the defendant posed a risk of flight, didn't explain the basis for the conclusion or its decision to remand him, other than saying what I just said. At that point, the defendant filed a habeas petition saying he was being illegally detained. That ultimately winds up being what's brought to this court, and the Supreme Court ultimately what happens here is the analysis from the Court of Appeals is, the question is that sufficient? Does that satisfy the requirement for an articulated determination under the factors of CPL 510.10? And the Court of Appeals says it does not. The Court of Appeals says it does not state on the record the defendant posed a risk of flight, let alone give a basis for its determination. And so it would require speculation or inference upon inference to determine which of the arguments the prosecution made the judge agreed with and which the judge didn't agree with. And they say, nor can we know whether the court determined the defendant posed a risk of flight because the court didn't say so. And risk of flight is the primary consideration since the 2019 changes to bail. They say the court's not required to engage in a lengthy discussion of all the bail factors, but it should at least, at a minimum, provide substantive reasoning for its determination as to whether the defendant poses a risk of flight and its selection of a securing order, and the court failed to do that here. So they say this is an abuse of discretion. They send it back to the court for an analysis that would comply, that would give reasons for its determination. And that's the case of People versus Maginley Liddie. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.